Good afternoon, everyone, and welcome to the Alternative Dispute Resolution Certification Working Group. It's good to see you this afternoon. And I want to remind everyone that this hearing is this meeting is being recorded. Ms. Marlott, would you please take the roll?
Yes. Armstrong,
Here.
Coulter,
Here.
Curtis,
Here.
Dinkin,
Here.
Dubois,
Here.
Ellis, Dr. Getz,
Here.
Higuchi, Hodgson,
Here.
Jones,
Here.
Kelly,
Here.
Kopaken,
Here.
Cruz,
Here.
Lowe is absent, Judge Lucky,
Here.
Palevsky,
Here.
Judge Pichon,
Here.
Robertson. I see you, Maddie. Thank you. Your volume is not working, but I do see that you raised your hand. Tuckman,
Here.
Welch,
Here.
and Yamshan.
Here.
Thank you.
Thank you. Next on the agenda is the call for public comment. State Bar staff will attempt to call members of the public in the order that they appear on the attendee pool. Ms. Marlott, would you please provide the instruction?
Yes, for those who are participating by Zoom, please use the raise hand function at this time if you'd like to give a public comment. And we will call you in the order that your hands are raised. If you're calling by phone, you can virtually raise your hand by pressing *9. We will give each speaker 3 minutes and you'll have a 30-second warning. Is there anybody who would like to give a public comment? Please use the raise hand function at this time.
And while Angela's looking, working group members mind muting themselves. We're getting some feedback.
I do not see any raised hands, Judge Pichon.
Thank you. And I do hear the feedback also. Next, we'll move to the approval of the minutes. It's the June 18 open session. Are there any modifications or corrections to the minutes? Hearing none, may I have a motion, please? Motion to approve. And I don't know who said that. May I?
Paul Dubois.
Thank you. And may I have a second?
Second.
Ms. Marlott, would you please call the roll?
Yes. Armstrong,
Yes.
Coulter,
Yes.
Curtis,
Yes.
thank you. Dinkin,
Yes.
Dubois,
Yes.
Ellis, Dr. Getz, Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Kopaken,
Yes.
Cruz,
Abstain.
Lowe is absent, Judge Lucky,
Yes.
Palevsky,
Yes.
Robertson. I don't hear you, but I see that you said yes. Thank you. Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
and Judge Pichon.
Yes,
Thank you. The motion carries with a majority.
thank you. Next, it would be my report, the chair's report. However, I do not have anything to report on at this time. So we'll move on to the staff report. And I believe we do have a report from staff.
Thank you, Judge Pichon. Just very briefly, one, I wanted to thank all of the members for participating in the poll to schedule upcoming working group meetings. You should receive a calendar meeting invitation from Angela tomorrow. I also want to acknowledge that the meeting materials for this meeting were just posted on Monday. And with 2 subgroup meetings last week, including one on Friday, we weren't able to finalize and post the material until Monday. So we appreciate your understanding, and moving forward, we're working to allow more time between subgroup and full group meetings so materials can be shared earlier for your review. Thank you.
Thank you. So we'll move on to the business portion of the meeting, and we'll start with item number 1, which is the report and possible action on recommendation from baseline certification requirements for mediators. And this item is being presented by Ms. Dana Curtis.
Well, thank you, Judge Prishon. And before I start, I want to acknowledge the hard work of the mediation subgroup. I believe we're very close to being finished, and we've met 6 times now, and every time was enlightening, and we had thoughtful discussions. And thank you also to the staff, and especially to Alan for his hard work. I know he would be glad to know that we're almost finished too. So with that, I will just say that we have reached, in those 6 meetings, we reached consensus on the qualifications for mediators concerning training, experience, a requirement for peer feedback or reflective practice group participation, recertification, although we won't be asking you to vote on that today. We did complete those, and I will review those with you. And then we also added a provision for inactive status, and I'll go into detail on those things in a minute. Also, to remind you, we have 3 paths to voluntary certification. The first is for people that have recently completed a qualifying training, which means that there were at least 25 hours in the single mediation training session. And then whatever the deficit is made up by various advanced classes that pertain to mediator training. And those, and in a minute, I'll show you the attachments that spell these things out. But we also outlined a number of content requirements for these trainings, and provided that if they haven't covered the governing ethical rules for mediators for certification, or the applicable rules, I guess we called it, then they must include in that training that sort of ethical training. So just also to remind you, as a basis for these requirements, we looked to the model qualifications for mediators in court-connected contexts that were created in 2011 by a group and were recommended to the Judicial Council by a group that of very experienced mediators that functioned at that time. So there are a couple of adjustments that we made, and I'll point those out, but that was the source that we looked to, thinking that people who thought about this over a year and then were reflecting on it, relying on them, and some of the learning was appropriate. So the second category was for people who had had a training, but it was more than 2 years ago, and the same requirements for that training to qualify. And then we had a separate path for people who had substantial experience and no formal 40-hour training. So that's to kind of catch you up on where we've been. So you received these recommendations in 2 forms. One is a table, and that follows the memo that you received that described our activity over the last few weeks. And then also you received it in a form of a text form, and that's the form I'd like us to look at if we could. Alan, thank you. And while he's bringing that up, as you know, we were also charged with modifying the existing rules of conduct for court-connected mediators to conform to our purposes, which we have done. You received those recommendations. We won't ask you to vote on those today, but I did want to mention a couple of things following our discussion about these qualification requirements, and also to sort of let you know a little bit about our deliberations on some substantive changes to these rules. Excuse me. Okay, so I just want to make sure that everybody can see them. That's great. Okay. Anybody have a problem seeing them? Raise your hand. And some of you may have some of you may also have printed these out, which makes it really easy. So the initial baseline requirements for those mediators who have been recently trained are the training, as I mentioned. It must have happened within 2 years prior to applying for certification, and it must include at least 2 hours covering the applicable standards of conduct, as I mentioned. It must also they must also have conducted at least 6 qualifying mediations within the 2 years prior to applying for certification, and have completed at least 3 hours of peer feedback or reflective practice group sessions within 1 year prior to applying for certification. And this requirement is repeated in each of the categories. And I think rather than taking time now to explain about that, I'll defer until the end and come back to a bit more about the peer feedback or reflective practice requirement. And so the second is for people who've had training, but it was more than 2 years ago. The training itself, the requirements are the same, but we also will require that recommend that we require at least 8 hours of qualifying continuing mediation training within the 2 years prior to applying to refresh that learning. And then 6 qualifying mediations within the last 2 years, and at least 3 hours of peer feedback, as I mentioned, or a reflective practice group. And then finally, this category is for those mediators that have substantial experience, but they have not had a qualifying 40-hour mediation training. And so they would qualify by completing at least 8 hours of qualifying continuing mediation training, and at least 5 qualifying mediations during each of the 5 years prior to applying for certification. This is a little different from what we mentioned last time. And at least 3 hours of peer feedback or reflective practice. And I see Ron's hand up. Ron?
Thank you. Can you explain how the 3-year sunset is intended to work?
Yes, I was just
you.
about to do that. So, yeah, so let me just explain what we were addressing by this requirement. So, to be very transparent, the majority of our group was favoring requiring a 40-hour mediation training of everyone. And you know that we realized that was probably not going to be acceptable. But so we're trying to work around this, and because I mean, after all, there have been people that have been mediating 30 years and maybe never trained, but they're very good and they have a very active current practice. So for a period of time, those individuals will be able to qualify as I just described. But we also believe that mediation training is valuable, no matter how long you've been working and train, and if you've never had one, the skills are quite different. And having just trained a whole bunch of retired judges to mediate us for the temporary assigned judges program, they were shocked at how different the role was and how much they learned and all of their so anyway, it's like I don't need to sell probably everybody here on this, but I'm inclined to do that. But so we wanted to allow people with a lot of experience to come into to get certified, but we thought that 3 years was long enough that to allow very experienced mediators to go back and have some fun in a 40-hour mediation training and learn some things. So that's basically it. Does that answer your question?
Do I understand it right that if I were a very experienced mediator and I'd never had a 40-hour training, I have to apply for certification sometime in the next 3 years after this is adopted, or else I have to go back and get a 40-hour training? Is that what this is supposed to say?
I'm so sorry. I'm gonna interrupt. Alan, we can see your full screen, everything you're doing.
Oh, your texts, Alan.
Maybe just stop sharing for the moment. Thank you. Sorry. Continue the conversation.
Whoops. Haven't we all had that happen? Yes, Ron, sort of. I mean, that's right.
Can I add to Dana's explanation just as a member of that subgroup?
Oh,
Is that
thank you, Betty. Yes.
part of the sunset is like, we don't want people just forever onward being like, oh, there's one path where I don't have to take a 40-hour and I can kind of like sneaky get certified. So partly also for like equity purposes, there's this sort of like grandfather period for people while this program is just starting up, but eventually that option will go away. And so then everyone will need to take some kind of a 40-hour.
Thank you. Thank you, Maddie. And that reminds me, I've pretty much gone through all of this. I wonder if the other subgroup members have anything to add or any clarification. I'll do that before I take your question, Dan. Just 1 second. Daniel, yeah. No? Okay, Daniel.
Thank you. I've asked the same question in the arbitration group. Have you given thought to giving training credit to presenters, people who present training? And under the current MCLE rules, a presenter gets 3 hours of credit for every hour of presentation, or 3 times their time. If you present for half an hour, you get an hour and a half. Has the group discussed that at all?
We have discussed it in terms of the enhancement. Honestly, do any of you remember? Because I don't. We discussed it, but I don't. In a minute, I'm going to come to recertification, and that is a place that we did consider those various opportunities to learn about mediation that aren't directly taking a training. And yes, that would qualify teaching and training yourself. But I don't believe there's we didn't provide for any enhancement. I think it's 4 hours if you're on a panel or you teach. So, okay, any other questions about the basic paths and the certification requirements to get there? All right.
I did have a question.
Yes, Eric.
It's about a definition. Can we raise those now, or would you rather we?
Oh, please. I didn't really get into those in detail, but so go ahead. Good idea.
With qualifying mediations, I understand, we want to make sure that that the mediations are real and substantive, sufficiently long in duration to count. But I'm just wondering if the group thought about what would trigger. I understand there's a time period, 2 hours, but it's from the beginning of the first mediation session. Some mediations, for large complex cases with large numbers of parties might have a lot of organizing calls where, you know, they get into the substance of the mediation. We've seen that happen, you know, relatively frequently. And I'm wondering if additional clarity needs to be given about whether that type of thing counts or whether it doesn't. Whether we need to clarify what the beginning of the first mediation session means.
I mean, that's a good point. I can tell you the intention, and then let's take a look at our definition. But the intention was from the outset of the, you know, when the mediation begins, not the pre-mediation activity, until the mediation concludes. So I don't know that we need to clarify that, because if the mediation has concluded, it means that there's been something going on. I guess there is the possibility that you have some interaction getting the case set up and then the case settles, but that's certainly not what we contemplated. So maybe we do need to go back and look at that, and I would entertain, you know, any other thoughts about that too. The other thing is that from beginning of the first session through the conclusion of the mediation, I mean, I don't know, does that cover it or do we need to define the beginning of the mediation or the first session or something? What are your thoughts?
I'll just add the scenario you mentioned where a case settles before, you know, maybe the formal session begins, where all the parties are present and not necessarily all together, but that is what I was getting at.
Mm-hmm.
I don't think conclusion of the mediation is an issue, but I do wonder if clarifying what the first mediation session is.
Okay. I have a question, Judge Pichon or staff, about proposing modifications. Would this come later, since we're not voting on it?
Yes, we were hoping to vote today if possible. And so it just depends on if the rest of the group feels that the word mediation needs to be defined, or if you want to add the word session, to say that that is the time period that we're referring to. That's fine. But I think it would be a good idea to look to our entire group to see if there's any issue regarding the meaning of mediation when that actually begins. So does anyone else have a question regarding qualifying mediation, what mediation means? Yes, I see Ms. Hodgson.
I will echo sort of the uncertainty or the question mark and perhaps further need for clarification on what we mean by convening a mediation. From my personal experience, overseeing a courts mediation program, I have had our panel of mediators do a really exceptional job in their pre-mediation work, and that exceptional job has ultimately led to the case settling before what we would, I think, ordinarily think of as the commencement of mediation and the convening, which has then, of course, led them to reach out to me and say, well, can't we call that part of the mediation? I would like, in this context, in my context, I would like to be compensated because my efforts did lead to the resolution. So I think there is, depending on what that pre-mediation conversation looks like, there may be some room for interpretation or some room for clarification.
Thank you. Anyone else?
Judge Pichon, may I say something?
Yes.
I forgot to say that we debated a long time on the length of time of the mediation. And I really learned a lot during those conversations about what occurs in the context of community mediations or a day of court mediations. But one of the concerns that I had was that if one has a 2-hour mediation, they haven't really gone through all of the steps of the process so that they have a breadth of skills that they are developing, which in a longer mediation was more obvious to me. But having been assured of the sort of that the phases of mediation, for lack of a better word, or the steps or the activities that a mediator has to handle and address and help with can occur in a 2-hour mediation, I was satisfied. But I don't know, I mean, I don't know that we could really say that about pre-mediation activity in the same way that one can say it if you actually have set the mediation up, you've actually begun the process in earnest. So I'm interested in your thoughts about that, but I just wanted you to know kind of the basis for what the expectation was for that 2 hours.
It may be difficult to define mediation in terms of the pre-mediation activities. However, I think that maybe the group can agree on when a mediation actually begins, that would be considered the session. So I need to know if our group can agree with that the mediation session is what is meant by qualifying mediations. Would anyone else like to comment on that? Yes, Mr. Kelly, I see your hand.
To the best of my knowledge, the law is pretty clear about when a mediation ends and how. There's 5 different ways identified, but there's nothing that specifies when it starts. My own agreement to mediate says it starts with the first contact with the mediator. And I spent a lot of time in preparing the parties to negotiate, understanding what they're going to be talking about. Sometimes there's never any joint meeting or anything that people would call a normal mediation. And it continues in caucus style all the way till a settlement. I think I'd like to at least support the people who are saying maybe there needs to be a better definition of when it starts. Because I don't think that's clear. It's not clear in the law, and I think it's not clear because of the variety of people's practices. Some people, like myself, get very much into the nitty-gritty, read documents, or talking to the parties about substantive issues before anybody else would think of the mediation starting. When there's no contact with a neutral, only their case manager until everybody gets together either virtually or in person.
Okay, thank you for that. So I saw Judge Lucky's hand first, and then I saw one other hand. Oh, yes, that's Ms. Copaken. Okay, so we'll take Judge Lucky, please.
I think Ms. Copaken had her hand up first, so I'll defer to her.
Okay, Ms. Copaken.
Okay, not that formal, but I think I share Mr. Kelly's observations that much of what happens prior to a formal session can be very substantive. I have a secondary concern that I want to make sure that we don't define what a mediation is to provide that those pre-joint session conversations are not part of the mediation and therefore are not subject to the confidentiality protections. So to me, once you're dealing with anything outside of the scheduling and you're dealing with the mediator, you are substantively engaged in a mediation process. I think we have set our requirements in terms of experiential requirements sufficiently high that you would hopefully have gone through all those stages that Ms. Curtis referred to, in over the course of maybe aggregating. Some cases, in fact, may settle prior to a joint, full, robust session, or perhaps in certain contexts like the family law mediators, I understand, do much of it in separate, facilitated fashion and may not actually be engaged in simultaneous conversation. So I just want to lift up that we were very careful that we don't define mediation so narrowly that we are causing confidentiality concerns for those pre-joint session conversations.
Okay,
Thanks.
thank you. Judge Lucky.
I was
Sorry.
going to say substantially the same thing, that I think that any activity in which a mediator engages to which the mediation privilege would attach, I think that's mediation. And so it seems to me that once that process has started, whether you're doing it over the phone in a pre-mediation or you're meeting people in court on a same day court run mediation. If we are engaging in activity that is covered by the privilege and is covered by our ethical duties, that seems to me sufficient.
Okay, thank you. And Ms. Curtis?
Yes, thank you. So I would agree for the purposes of confidentiality and that definition, that mediation begins at the first contact. I think it even says that. But what we're looking at here is we're figuring out, does a mediation qualify? Does this qualify as a mediation for the purpose of certification? And what I'm concerned about is that if we allow, and I think we can define mediation differently from the way it's defined in the evidence code, or maybe even in the way that it's elsewhere defined. So for the purposes of recertification, for example, the mediation begins with the first session. And I've already said why I'm concerned that mediators may not have sufficient experience, although they may too. It's just that, how do we draw that line? Thank you.
Okay, thank you. Ms. Hodson?
Perhaps in discussing how we wish to define mediation, I think the points about mediation confidentiality attaching to communications are something we must keep in mind. But as we are talking about, is the definition different than the evidence code? Perhaps we need to discuss what the subcommittee's goals were in requiring a certain amount of hours of quote unquote qualifying mediation. I'm reluctant to recommend a definition that doesn't encompass a variety of types of mediation or formats of mediation. I think a lot of mediators meet the parties where they are and the case where it is. Some cases and some parties are very amenable to working together in the same room. Some simply cannot see each other or have transportation issues or whatever the case may be. I would hate for us to say anyone who is conducting their mediation, not by convening everyone together, is not able to be certified because they don't check the box for qualifying mediation. So I want us to be mindful of that.
Okay, thank you. And Mr. DeVoe?
Yeah, I agree with Sarah. I know my own practice, especially since we've gone a lot of Zoom mediations. I find myself have the majority of the mediations in which I am retained never go to a session. I've been able to settle over half my cases without a session by just reading the briefs and then calling the various attorneys and eventually hopefully get a settlement. So I don't think that the first session should be the criterion for recertification.
Thank you. And for our record, Ms. Jenna Ellis has joined.
Hi, everyone.
Hello and welcome.
Thank you.
Right. So we've had a number of comments on when a mediation begins. I'm going to ask Ms. Curtis if you'll finish your presentation, and then you can let me know, based on everything we've heard, whether you would like to take that back to your group. I was hoping that we would vote today, but if we can't, because these comments are very important and they've been excellent comments. Ms. Curtis, so if you would like to finish your report, then please give me your recommendation as to what you would like to do with the comments that have been made thus far.
All right, thank you. So just to pick up, one of the requirements that we recommended was peer feedback and reflective practice groups. And I'm imagining that every mediator here on this in this meeting has engaged in peer consultation at some point. So I think that that's self-explanatory. It's informal. It's an opportunity for people to talk about their cases either in an ongoing way or reflectively after they're ended so that they can learn from them. And then reflective practice groups are groups of several mediators who work together. It's either a facilitated group or a peer facilitated group, where the purpose is to promote professional development and ongoing learning by actually spending time reflecting on ethical issues that have come up during the mediation, difficult situations, difficult parties, difficult circumstances, and being able to talk those through, think those through, reflect on them, get questions from peers, and examine them in more detail. You know, we practice in isolation, and it turns out that we're not very good at self-describing, and we're not, and this is from the research, we're also not very good at sort of auto-reflection. It's kind of it's a loop. We're also prone to finding a way that works and doing it the same way over and over again, and there are so many more sort of opportunities that are available when there is this kind of reflection, and especially in ethics. There's some research that just knowing the rules and going over them and enumerating them is really not very helpful, because it's in the details and in the depth and in the moment that those dilemmas arise, that that we may miss something that some of our peers have seen. So especially, I think, as we undertake this particular task where ethics seems to be front and center, that these groups provide opportunities. So I don't know if you have any questions about them. Jill Kopikin, who's in our, it's not 3:30 yet, Jill, has run these groups, as have I, and so happy to answer any questions.
All right, Ms. Curtis, does that complete your presentation so that we can officially questions?
Oh, no.
Okay.
All right. So to finish, I'd like to talk about our ethical approach to the changing the ethical rules. So the red lines that you see are really, with one exception, which I'll mention, those are designed just simply to conform the rules to the context of voluntary certification with the state bar, as opposed to being in the court-connected context. So that's what you'll see, or you have seen if you've already looked at them. There is one change that we believed had more to do with process, or I should say administrative process. And that is that we changed the rule that says the mediator must agree to disclosures in complaint procedures. So that we felt that was more appropriately handled by another subgroup that deals with administrative procedures. So that so there are a couple of other things, but maybe we should take questions now just on that red line of those changes. And Judge Bichon, do you want to?
Okay, that's fine. Thank you, Ms. Curtis. So I'm going to go to Mr. Weiner first and ask if there's anything you'd like to say, and then to Ms. Ellis.
Thank you, Judge Bichon. I don't have anything at this time. I may later.
Okay. All right. Thank you. And Ms. Ellis?
Nothing right now. Thank you, Judge Bichon.
Sure. So, Ms. Curtis, we can do as you ask, and that is to take questions. And I see Mr. Dubois, your hand is up.
Yeah, I know Dana's asked about the red line, but I want to go back to the reflective group issue. And I understand the need for learning more things, and I agree that sometimes being in isolation doesn't help us too much. But there are other ways to find out things in mediation without sitting around a table with some of your buddies. And I think you might want to add, if we're going to have this reflective group requirement, you might want to add to it instead of having a session with the reflective group, if the mediator also attended a webinar, let's say, on the subject of the problems of mediation, something of that nature, that also would be satisfactory.
All right, thank you. And let's see, I see Mr. Pulaski.
Thank you. A couple things. In the ethics rules, one of the rules says you can't have contingent fee. And I know of some mediators who have a normal practice, but they also have some super big case mediation with a contingent fee. And I'm trying to figure out what that means for certification. If you, let's assume you have a normal practice and 2 of your mediations a year violate that rule. Is that considered an ethical violation that would disqualify you from certification if you have any contingent fee mediations? That's one. I don't do mediation. I'm just curious about that. From a drafting standpoint, going back, I think that the peer review is a good idea. I think it's really hard to define, and it sounds pretty loosey-goosey. And I completely respect this group, but it's being brought over into the arbitration group. And I think it's really important to define what that really means and if it's real, because peer reflections is really hard to measure. And then for both your group and ours, I still want to make sure I understand the significance of complaints or ethical violations being determined on recertification.
All right, thank you. Mr. Kelly?
I don't know whether Ms. Curtis wants to respond to any of these before I bring up a different issue.
Oh, okay. Let me see. Let me just take one more. Let's see, Ms. Jones.
Yes, I was just curious, point of clarification, if the working group had discussed any of the kind of mechanics of reporting on these things, if they'll all just be self-reporting or if there has to be any kind of like formalized structure for people to document and report these programs that they participate in.
Thank you. I don't see any other hands besides Mr. Kelly, and you've indicated that we might come back to you, which I will do.
Well, no, I want to bring up something about what Ms. Curtis has been talking about, but
Okay.
I don't know whether she wanted to respond to any of the previous questions first. I'm happy to bring up another one. I don't know how many you can remember, Dana.
I'm writing them down.
Okay.
Go ahead.
Judge Pichon, Ms. Cruz also has her hand up.
Well,
all right. Mr. Kelly, do you want to go ahead? And then I'll go to Ms.
I
Cruz.
would like to. First of all, I don't know how many people got a chance to review all of this since most of it came out yesterday. So and it said we weren't going to vote on it. So I think it's improper to vote on this at this time. I'll just say that. But on a specific point, as most of you know, mediation confidentiality is near and dear to my heart. And Mr. Weiner and I were both participants in drafting some of these, and the rule 3.860, the B, that this recommendation would eliminate, basically that the mediator has to agree to disclosure about communications for complaint proceedings. It's kind of subtle, but my understanding of the intent of this was that the first part, which is A, says the mediator has to make sure that everybody there completes an attendance sheet with their contact information, that the implication was that whoever's the complaint coordinator needs to contact all the participants and see if they're okay with mediation communications being disclosed. And it specifically says the mediator doesn't get to have a say saying, no, I don't want any mediation communications to come in if they're complaining about me. These two work together in the rules of court, and eliminating one of them, to me, sends the message that disclosure is only have to do with the mediator, that the waiving of confidentiality only has to do with the mediator and not the other participants. So until and unless I see something really clear in a different set of whatever we may be approving, I'd be strongly against deleting that section B. So that's my point. Thank you.
Ms. Cruz?
Thanks. So I first of all second Ron's comment about waiting to vote to the next meeting, given how short of a time frame all of us have had to review everything. And something and just for a question for the mediators group that I was struggling with in the arbitration group is the notion of peer review and feedback. And as initially kind of defined, it was in my mind more of a shadowing sort of obligation. But looking at footnote 4 and the materials that were sent around, I also think more clarity needs to be put around the definition of what that is, if we are to include it. For example, if I talk to my friend Judge Pichon for 3 hours about, you know, X, Y, and Z mediations, that's all you need? And my last concern there is on confidentiality again, too. I think that seeing this requirement, especially a young neutral, might be confused about exactly what they can and cannot talk about in peer and reflective groups. And I don't want people to stumble and accidentally or inadvertently do something that's unethical under the guise of trying to meet this requirement, right? So I think we should, if we are going to do this, which I second Paul's comments that I'm not sure the value of it fully, especially not in the arbitration context. But if we're going to do it, I think we need to remind people of their confidentiality duties. Like when you talk to your peers or when you have these reflective group meetings, you cannot do X, Y, and Z and disclose specifics. So that's just some more thoughts for Dana, your and your group's consideration.
Thank you, Ms. Cruz. And Mr. Weiner?
Yes, thank you, Judge Pichon. I appreciate everyone's. I just wanted to clarify about what the intention about voting and postponing voting was. The red line version of the rules was provided as part of a report at this point in time, because that's something that the subgroup had been working on. And it wasn't intended as a vote at this meeting. It's not on the agenda for a vote. It was just provided to show what the working group had been done. And also, I think, allows more time for the full working group members to reflect on that. I think many of the comments that have been raised by Mr. DeBow, Mr. Palevsky, and Mr. Kelly, and one of the comments by Ms. Cruz, I think go directly to the red line version. I just wanted to assure all members of the working group that the intention is that we will come back and discuss that document entirely. Nothing is being deleted or voted on being deleted at this point in time. So the comments are helpful. And, if this goes back to the working group, perhaps the working group will also, if the qualification requirements go back to the working group, perhaps Ms. Curtis would also ask the working group to consider some of the preliminary comments that have been made about that red line version at this point in time. And also to reiterate a couple of things that Ms. Cruz said, that there's this crossover that we've been struggling with a lot between what kind of fits into sort of the administrative aspects of the program and what's more substantive. And we've kind of been collecting a list of things for the administrative side of things, like how often, what type of renewal or recertification. And so we are contemplating that a new subgroup will be formed at some point in time to address those kinds of issues. So just wanted to assure everyone that, nothing that's in the red line is, you're not being asked to decide on anything, and there'll be ample opportunity to discuss it in the future. So thank you.
Thank you, Mr. Weiner. And Ms. Cruz, I see your hand is up.
Sorry, just still up from before.
Oh, okay. All right. Thank you. All right, Ms. Curtis, you've heard everything. If you'd like to respond to any of them, you certainly may at this time.
Well, I think given the issues that everyone's raised, particularly about peer review, in terms of the qualifications, it would make sense for us to consider the comments and come back and have, so I don't know that it would be helpful for me to address some of these points right now. I'm happy to do that, but I think that we can have a full discussion of them at a later time, and perhaps even, include in the memo a few points that address these things. Does that make sense?
Wise, I think.
Okay, and then that's the same is true for the red line version. As I said at the beginning, we weren't going to vote on those anyway. But I do have a question, and that is, Ron, or anyone else on the complaint committee, did you take up this issue about confidentiality? Because I mean, I think that would be an appropriate committee to deal with this issue. But it just occurred to me right now, either that or the administrative, but if, I don't know that your committee addressed this.
Yes, Mr. Kelly.
Well, I can tell you that in our working group and in discussions with staff, there's been quite a lot of talk about confidentiality and how would that work in the certification program. So yes, that's been quite an active topic, if that's your question.
No, I was asking if the complaint subgroup had addressed this, because that would seem to me an appropriate topic for that subgroup.
I'm sorry, that's what I was talking about.
Oh, I thought you said the working group.
I might very well have. I'm sorry. I meant the complaint subcommittee.
And could you remind us of what the conclusion was about that issue?
I think in many ways, the conclusion was that those of us who had different views were going to have to wait and see what the Court of Appeals says about it. I don't know that we've come to a consensus, at least none that I could identify.
All right, so then I suggest that we take this up as, in our subsequent meeting, and as well as all of these other things. And I'm happy to answer any particular questions that are burning at this moment, if you like. Oh, Alan, you had something.
Yes, Mr. Weiner.
Yes, thank you, Judge Bashan and Ms. Curtis. I was just going to say, so there are a couple of matters that, I think questions were raised about around the definition of when does a mediation begin, for one thing, and also about, clear definition of the reflective practice or peer discussion requirements. But there's some other aspects, I think, of the proposal from the mediator subgroup that it would be helpful to either vote on, or at least to get input from the working group on, so that if the subgroup is going to meet more and there are other issues, that those could be taken up. So for example, Ms. Curtis went through the kind of 3 tiers, if you will, or shouldn't use tiers because that confuses it with something else. We called them pathways, the 3 pathways to certification, with different numbers of hours of training or numbers of mediations completed. And I just think it would be helpful to have received the working group's input on that. So if the subgroup is going to meet more and there are concerns there, they could be discussed at the same time.
Good point.
Thank you, Mr. Weiner. That is a good suggestion. So I think if we look at the chart, we'll be able to see what Mr. Weiner was referring to. And those were the three pathways listed in the chart. Does anybody have any comments related to the chart? And Mr. Weiner is putting it up. That does contain the three pathways. And I see Mr. Tuckman's hand is up.
This is just, in terms of getting input, at least from some of my colleagues. So I don't have any particular additional issues to raise, but I do feel as though, at least in terms of representing the views of the AAA, it would be helpful to be able to even to have a short amount of time to make sure there are no additional comments on these. Again, personally, I think a lot of this makes sense, but I'm just a little concerned, given the amount of time we've had to consider these, that at least some of us might not have had the opportunity to get the input that we need from our colleagues. So I'm just a little reluctant to vote. I'm happy to talk about them and get a general consensus, but even a short amount of time to make sure that we get additional input as needed would be very useful.
Okay, thank you. Mr. Yamshan? You're muted, Mr. Yamshan.
Thank you. I'm sorry. I agree. I've been reporting to our county bar ADR section on the progress and the discussions. And there's a tremendous amount of interest in this, as you might imagine. And I think, just as it's been suggested that there's peer reflection, that I think the different constituencies are going to want to discuss these things in depth.
Thank you. And Mr. DeBoe?
Well, I have no strong feelings that I'll vote either way, except for one thing, and that is the peer feedback or reflective sessions, which I oppose. And I think we should separate them out. And I don't like them again because I'm really worried about people sitting down together, talking about their cases and slipping up on confidentiality. And as I mentioned earlier, I think the same could be accomplished by requiring arbitrators or rather mediators to go to the equivalent of an MCLE course to learn and where practice issues are discussed. There are plenty of them out there, and you could easily get involved in that. And a lot of these involve questions from the audience, so it would have the same effect as the peer feedback.
And Mr. DeBoe, did you mention the webinar earlier?
I'm sorry?
You mentioned the use of a webinar for this purpose?
I mentioned that earlier, yes.
Okay, and would that webinar be interactive, or would you just be in the audience and not be able to ask questions?
That's a good question. It'd probably be better to be interactive. I'm not sure I want it as a requirement because you still learn. So I can't answer your question right now. I have to think about it.
I want to know what you meant by that.
Okay.
Okay, thank you. Ms. Cruz?
I just second all the previous comments that I think that we're going to have a better final proposal and a stronger vote if we defer this and allow the mediation subgroup to look at these things carefully. I also wanted to sort of second something that Eric said specifically too, and just sort of throw it out to the group. I've heard rumblings from a lot of practitioners that if these are going to be the requirements, why get certified? Because there's all these crazy hoops that we've never seen before. And I think it would be very helpful at the next meeting to get feedback from some of our larger institutional providers like the AAA, JAMS, ADR Services, Judicate West, as to what they're hearing from their neutrals. because the program is voluntary, and it would be a shame to set something up that everyone opted out of because the bar was so high. And then last but not least, just a final point, if the mediation group does talk about, these are all on the baseline, and we still have 2 tiers to discuss. And if we're setting these numbers this way, have we taken into account what you're going to put on tier 2 and tier 3 in addition to it? Because while there's tons of 40-hour programs, if tier 2 requires 80 hours, et cetera, I'm a little concerned that we might not be building enough wiggle room to go up from where we are in certain numbers and certain categories.
All right, I see Ms. Curtis's hand is up and Mr. Weiner. So
Let's hear from Ms. Curtis first.
Oh, I was going to have you go first. So I'll let you address the tier question. And I would like to just say that I don't know that Mr. Weiner was suggesting a vote on individual parts of this. I think what I'm interested in on behalf of our subgroup are comments, so that when we go back and we're reflecting on the comments that have been made so far, but we're not going to come back and then there are more. Because I think, if we could take a look at those again, and I appreciate that that the time was so short. But maybe we could, as Judge Pichon, you suggested, is let's take a look at that and at that document that you had up, Alan, and see, if there are any other concerns or things you'd like us to think about and talk about. That would be very helpful.
All right, thank you. And Mr. Weiner?
Yes, thank you, Judge Pichon. I'm going to sound a little bit like a broken record on this, but I wanted to again say that there are going to be opportunities for public comment, both before the working group makes a recommendation to the State Bar Board of Trustees, and then the State Bar Board of Trustees will also ask for public comments on it. So that's one thing more or less on the back end. To Mr. Tuckman and Ms. Cruz's comments, though, I think that perhaps building in a mechanism, as Mr. Tuckman said, for him to have a chance to speak to colleagues on, as part of the AAA, I think would be helpful, and to get comments, for other folks who are here from provider organizations, to get comments from those organizations, because it was, it's really been only a matter of 2 days since the materials have been available. And so a lot of folks haven't had the opportunity. I think folks on all 3 of the subgroups have had some conversations with colleagues, but not everybody was on each of the subgroups. And so I think some more opportunity there would be appropriate.
All right, thank you. And I think that I saw another hand. Ms. Cruz, did I see yours? Okay, all right. So before I give
Judge
it back,
Pichon, I saw Ms. Ellis's hand just a minute ago. I'm not sure if I addressed what she was going to.
okay, Ms. Ellis?
Alan read my mind. I was going to say the same thing.
Oh, okay, thank you. So is there anyone else? Now, it sounds like Ms. Curtis is requesting to take this back to her group, these comments. I think I already said that I agreed with her and thought it was very wise. However, I would like for you to look at attachment 3 first. And these are basically the definitions. And is there any other feedback you'd like to give to Ms. Curtis so that they can consider all of the comments before they go back to their subgroup? Yes, it's this one. Thank you, Mr. Weiner. So it's on this page, would you look at qualifying continuing mediation training? Qualifying mediations, and you've already addressed that in terms of when does a mediation begin. We've talked about the reflective groups, so we have that. And qualifying mediation related activity. Do you have any more comments to make regarding these to give to Ms. Curtis to take back to her subgroup?
Judge Pishon, could I make a comment about the sunset provision for the more experienced
Yes.
pathway? I just wanted to make sure I understand. From what I'm seeing, if after that pathway sunsets, after 3 years, the requirement would be for all mediators who would hope to be certified to then have to take at least 25 hours in a consecutive course. I think that would be the effect after the 3 years. And so I just wanted to highlight that and draw some concern that the ultimate effect may be down the line, kind of closing opportunities for potential mediators who may not, be able to necessarily afford to do an extensive training course. Thank you.
Thank you, Ms. Ellis. Ms. Hodgson?
I echo the concern about the sunset provision. I'm worried that it may create a chilling effect. And I wonder if, and I apologize if I missed this group's discussion about this piece of it, but the idea of recertification and continuing education and things like that, if that educational component related to recertification would accomplish the same goal, or what are we trying to achieve with the sunset that is not achieved by continuing education for certified mediators?
Thank you. Is there another hand?
Judge Pashon, if I may.
Mr. Weiner?
Yes, I just wanted to maybe clarify what I believe the understanding of the subgroup was, and that is that anyone who has met the qualifications for the, if you will, for this path that would sunset, as long as they kept up with the recertification requirements, they would be able to remain certified. The idea, I believe, of the subgroup was that new folks wouldn't be able to come in and qualify on this path. As Ms. Curtis said, conceivably somebody could come in and do, a large number of mediations in a short period of time. And the idea is that folks who don't become certified in the first 3 years would need to complete the next level of training. Perhaps it would be either the first or the second level.
Thank you. All right, are there any other comments or questions that you would like to give to the subgroup? On anything? All right, so Ms. Curtis.
Yes. We've mentioned in passing the idea of an inactive status. And I think if you were looking at that, and that didn't come up, but I just wanted to clarify that if for some reason a mediator wasn't able to had medical issues or family issues and they had to take time out, that there was a provision here that if they did so, then they could come back and meet the recertification requirements, and that they would have an extra year to complete their mediation. So I just wanted to make sure that we talked about that so that you weren't surprised next time. And if you have comments, we'd be happy to take them.
Thank you. Now, our subgroups have been working very hard, and as you heard, they have been working up to the last minute, which is why you didn't get your reports as early as you would like. I've heard many comments saying that you would like to review this more and have more time with it and to digest its contents, which is fine, and it's what we should do and what we want you to do. So I'm going to ask Ms. Curtis, would you like to take the comments back to your subgroup and then either change it or not change it or resubmit, whatever you'd like to do based on the comments that you've heard today?
Yes, we'd like to take them back to the subgroup, consider all of these comments, and if we deem it appropriate, we'll present modifications and make those clear to you in our next memo.
Right. And I'd like to thank you, Ms. Curtis, for all of your work and all of your members, all of the subgroup members. You've done enormous work and you've been very dedicated and committed. Thank you so much. So I just want to make sure that everybody has said what they need to say so far. so that Ms. Curtis can actually take this back to her group and they can consider this. Mr. Weiner?
Yes, thank you, Judge Bashan. It was just occurring to me, several members had indicated that they like to speak to colleagues. I'm thinking particularly of, Mr. Tuckman. If folks have comments that they would like the subgroup to consider that haven't come up today, perhaps they could send those to staff and staff would forward them. We need to avoid the direct communication between non-subgroup members and subgroup members because of the Bagley-Keene requirements. But I think it would be helpful, for example, Mr. Tuckman, if you get feedback from your colleagues, if you can provide that to staff so that we can share it with the subgroup before they reconsider the in light of the comments they've received today.
Yeah, absolutely. And maybe if you share what the day of the next meeting is of that subgroup, I can just make sure we work to get those comments before their meeting.
Let me ask it a little bit differently. Would it be reasonable to ask that folks reach out to your folks, constituents of your organizations within a week and get back to staff within that time, at least preliminarily? Again, keeping in mind that there are going to be two cycles of more formal comment opportunity. Again, we'd like the subgroup to meet as soon as possible so that we can get any new materials back out to all of you before the next work group meeting, which is August 20th. So that's the only reason I'm suggesting we approach it that way.
Sure. I can do that at least with internal staff, AAA folks. I think I can work within that time frame, although, everybody's schedules are busy. I do want to clarify, though, the suggestion earlier was to get a little bit of feedback more broadly from, I think I was hearing mediators or potentially arbitrators, depending on how that discussion goes. And if you really want to convene any type of group or have the discussions are going to be meaningful, that might take a little bit longer. But maybe that's a question back for you or others in the group, if you want that type of broader input at this point.
I think the view of the state bar staff is that there'll be the opportunities for that later. We've tried to select working group members who are, experts and well-versed in your fields. We'll do the best that we can to put the first proposal that we seek broader input on together, and then we'll get the broader input on that. It will come back to the working group, and you'll wrestle with those comments, and then there'll be another opportunity for the broader constituencies to reflect on what's put before the State Bar Board of Trustees.
Okay.
So
thanks for that clarification. Sure,
yeah,
that
we
makes
don't
sense.
really want to, yeah.
But if you could also maybe, at least I've got a question about what these subsequent next steps are. And I think we've heard about them, but I'm not sure quite I know what the timeframes are. So, for the additional opportunity for comment, I understand that's probably, regulatory, it's required, right? You've got to get comment on some of this, but can you provide a little bit more?
I can, yeah. So I guess the answer is as soon as possible. One of the things we're, sort of the steps that we're looking at going through or the conclusion of the existing subgroups, recommendations and consideration of them by the full working group. And then we have 3 more subgroups that we contemplate forming, provider organizations, tiers, and sort of the administrative matters we've talked to. And then we want to have one package put together along with some of the drafts of what the actual state bar rules might look like, and have that all together before we send something out for comment. So it's fairly complete. Then get the comments on that, and then come back to the working group, and then the working group recommendations to the State Bar Board of Trustees. There's a great desire on the part of the State Bar to move this forward quickly and to have the program ready to go before the State Bar Board of Governors and to become operative. We want to do it right, though, so it's a little bit of a balance on those things. I think we certainly hope that we might have something out for the first round of informal comment in the late fall, but that sort of depends on this group and its subgroups timelines itself.
Okay.
Thanks.
And I think it's very important to remember that what we're trying to do now is make a decision in this working group so that it can go out for public comment. So we are trying to hear from everyone who wants to be heard regarding this. So even if you talk to, your people or whoever you're associated with or whoever you feel is very important to receive information from to give to us, it still will go out for public comment. But before we can do that, we have to get it out from this working group. And I don't want to offend anyone by saying that each and every one of you were selected for your expertise and your skill and your knowledge. And we feel that we can greatly benefit from what you feel individually. So I know that you're all connected, but you were chosen because you're very special in this field and we value your input. All right, so Ms. Curtis, do you feel that you have enough information to take back to the subgroup?
Yes, I do, and I'll ask my fellow group members, subgroup members, if there are any questions they have of the working group. Okay, thank you all for your comments. They're very thoughtful, and I look forward to deliberating and coming back with a reasoned response.
Thank you, Ms. Curtis, and thank you so much to your subgroup, to all the members of your subgroup. All right, so now we'll move on to the update report and possible action on recommendation from baseline certification requirements for arbitrators. And that presentation will be made by Judge Lucky.
Thank you, Chair, Judge Prashant. And I want to start off the same way Ms. Curtis did. And first, thank staff for all the work they put in. Thank you to, and I'm going to say Mia Ellis, because we have two Ms. Ellises in our group. So thank you to Mia Ellis for jumping right in and picking up where Erica Doherty had left off. Thank you, Alan, for all your hard work and getting down what we talk about during these meetings and also giving the benefit of your insight. And thank you especially to my group. We have, I will say, animated and vigorous discussions, and I think we all learn from them, and we're working towards consensus. I don't think I'm speaking out of turn when I say that although as a subgroup, we're pretty confident where we are on the training requirements, the different pathways and experience, that I believe that we're not ready to make a recommendation yet, especially because of some of the great concerns we have about the peer consultation component that staff is recommending. And number one, making sure that we feel confident as to what the definition of that is. And number two, that we feel confident about what our recommendation would be. But I think that in terms of training and experience in the different pathways, we're fairly close to having our recommendation finalized. So, and Alan, if I could ask your help, I think we can just jump to the attachment 2 with the grid, because I think that that does a nice job of summarizing. And I'm going to steal that idea from Dana Curtis when she was doing hers, because I thought that that was very helpful.
Just saying, I was standing by with the textual version.
Oh, I'm sorry.
but I'm going to pull up the grid. Just bear with me 1 second.
No problem. Substantively, I feel that they're pretty similar, but the grid does a nicer job of putting it in a nutshell.
Are you seeing that now?
Perfect. Thank you so much. So as you can see, similar to the mediation subgroups recommendation, we have columns for path training, experience and peer consultation, and then the horizontal bands are different paths. So we'll start with not admitted to the practice of law. I think that one of the concerns that we had as a subgroup is that unlike mediation, where it's an important process, but not a decision-making process, where notions of due process, notions of being able to have an opportunity to present your case and having some statutory requirements on what arbitrators are supposed to do don't apply. We felt that when we have lay people, and I'm using that term broadly, but non-lawyers or non-judges engaging in this, we would want to have some assurance that they are familiar with giving people an opportunity to be heard, ex-parte communications, those types of issues, because we all know that there are very qualified arbitrators who have no legal experience, but are subject matter experts, have different qualifications. But for certification, we felt that for someone to be making binding decisions on disputed issues with very limited chances for review, that we wanted to make sure that they had either experience or training that would qualify them to hold themselves out as certified. So 30 hours is basically a semester course, and we saw that there are semester courses available for people outside or who are not members of the bar. And so we thought that 30 hours of that type of basic arbitrator training, which we do have defined later in the attachment, but goes over the different areas that we thought would be appropriate. And we specify, and you'll see this as a recurring theme, that at least 2 hours would cover the Judicial Council ethics standards for neutral arbitrators in contractual arbitration. We have the experience requirement that if in lieu of the training, that someone could have at least 3 qualifying arbitrations. And that definition is a little bit shorter. I'll tell you, we talked about this quite a bit, but I think that we reached the conclusion that although arbitrations, unlike mediations, where you schedule a mediation, sometimes those finish in a single day. You can schedule several of those, and they make their way from the beginning of the process to the end, sometimes during the same day, sometimes, as we all know, over a course of months or even years, depending on the mediation. But the numbers you can get up a little more quickly than, say, an arbitration, where from the time that you are appointed on an arbitration until the time that you reach the award stage can be months or years on the regular. And also that many of those cases settle, that many times the percentage of cases on which you're appointed that actually make it to the point where you're issuing some type of award can be as little as 5-10% of the cases that you get. So we felt that 3 qualifying arbitrations, meaning from inception to award writing stage, and we did talk about does that include interim awards? Does it include partial final awards, or does it only include the final award? And I think our consensus was if you're issuing an award on the merits, including even an interim award, many times the parties will settle the case after they see the interim award. And so we felt that a qualifying arbitration would include the different forms of award that an arbitrator might issue. Peer consultation and case discussion, again, we respectfully disagree with staff's recommendation on this. At least that was the consensus of the group. But we did talk about what that looked like, and we talked about what our concerns were. And I think that those are reflected well and accurately in what staff has produced. And we've also heard some of those concerns during the mediator discussion, so I won't belabor them here. But I'll give my fellow subgroup members a chance to chime in after I'm finished if they want to add anything. For admitted to practicing law, you can see that we have fewer hours required, and the fewer hours are based on the fact that with someone passing the bar, we know that they have some knowledge already of what evidence rules might be, civil procedure, notions of due process, etc. But you can see that we have 8 hours of basic arbitration training at any time, and then an additional 8 hours of continuing or advanced arbitration, again, with that 2 hours of ethics standards within the 2 years before seeking certification. We also have at least 6 qualifying arbitrations, with at least 3 within the 2 years prior to applying, and the peer consultation is the same. Then we have our experienced practitioner without the basic arbitration training. And you can see that there, what we've done is cut the 8 hours of basic arbitration training, increase the number of qualifying arbitrations to 12 total, with at least 3 within the 3 years prior. And then lastly, for recertification, 4 hours of continuing training, 1 hour of ethics, and at least 3 qualifying arbitrations within the prior 2 years. And we did have a lot of discussion on whether that left enough flexibility for folks who wanted to be in the game, but possibly not full-time players. And we felt that this was a decent standard that allowed consumers to have some confidence in the experience level of an arbitrator, and that they had met ethical training requirements, but also not so onerous that somebody who was well qualified but maybe not as active would be able to maintain their status. Before we take questions, I'd love to make sure that I give my fellow subgroup members a chance to weigh in. I know Jenna Ellis has to leave, so I'm going to let her go first just in case. And if she has nothing to say, we'll let her disappear.
Thanks so much, Judge. I think I'm okay for now. I do think we had a little bit of discussion around the number of qualifying arbitrations for those not admitted to practice and those admitted, but I think we can continue the conversation later.
Thank you so much. All right, and I think at least on my screen, going from right to left, I have Cliff Pileski's hand up first, so I'll cede to him.
Thank you. With regard to non-lawyers, I did express, and I do have a concern, because in arbitration, more and more, we're seeing legal matters that would normally go to a court being delegated almost as a tactic to arbitrators, which means they have to rule on unconscionability, arbitrability, and lots of complicated legal issues. And I just have a concern. I recognize that there are some great arbitrators doing specialized construction and medical malpractice and things of that sort. But I just have a concern about non-lawyers being certified by the state bar. Not that they can't practice and they can't be arbitrators, but I sure think that you need a legal background to make binding legal decisions that impact people's lives. Just my own personal belief about that.
Thank you so much. Anything else before we hear from Diana Cruz? Cliff, anything else before we?
No, I'm good.
Took his hand down. Perfect. All right, Diana.
Hey, just wanted to call on the state bar again to get this training ready to go, or commit to get this training ready to go for arbitrators. As I think I've shared in the subgroup a lot, and hopefully with this larger working group, I'm really concerned that there aren't any good available options. If you look, Alan graciously compiled a list of everything that's available. most of the training is not available to the public, right? So the JAMS training, for example, our JAMS representative on this panel confirmed that I can't sign up for it, for example, because I'm not a JAMS arbitrator. The 4 that are commercially available all cost thousands and thousands of dollars, and require for example, 200-hour commitment. And so we are really putting some people in a very bad space, potentially if we especially for people not admitted to practice law, if the state bar does not offer something at a cost-effective and immediate online availability. And so I know that a lot of our working members would graciously volunteer their time to be part of that training. But I do think it's very important that if we ultimately recommend things as high as 8 and 30 hours, that the state bar actually offer that. Because right now, if you are a member of the public and not a JAMS or Adjudicate West person, for example, you have to sign up basically for a master's degree at Pepperdine, which I think is going to have a massive adverse impact on diversity, especially people in lower income classes, unless there's something that's available to people at a lower cost. And I'm hoping that the state bar will do that.
Diana, thanks so much for that, because that's something that I left out. I think that that is very much the consensus of our group as well, is that for these training requirements, because I realize that there is a sense from some of the working group that, well, if you build it, they will come, right? If we require it, then programs will pop up. And although I think that's a decent bet and that's an aspirational notion, it's not a guarantee. And I think that the group feels very much that if these are the training requirements, then there must be some pathway for people to get this qualifying training through the state bar or through some low-cost means so that it doesn't become a barrier to entry. And then I'll just make one clarification. There is a JAMS training that is exclusive. Alan's training that he lists on here is actually not the same training, at least we don't think so. This was a training that he found on the JAMS website with a link, but we weren't able to access it. And I haven't gotten information on this particular course, but it is true that generally speaking, the JAMS arbitration training, like many providers, is exclusive to its providers. And at least at this time, I don't know of a JAMS course that would be generally available at low or no cost for arbitrators outside of the organization that would want to be certified. Okay, I think our next hand up is Ron Kelly.
Can I respond? I'm sorry, Joe.
Oh, yes.
You can comment real quick, just because I think it'd be helpful while we're in that topic, if that's okay with the others.
Please.
Okay. So I think I have not been at the most recent subgroup meetings on this, but I was at some of those meetings where this was discussed. And I think this is really a policy decision that the working group is going to have to consider in whatever the working group's recommendation is. As all of you know, by statute, this is required to be a self-funded program, and development of education by the state board, or frankly by any organization, costs money to develop. And so if this is something that the state bar is going to develop, I think that's something that we could certainly explore. But the development of that education would be borne by the applicants to this program because of the requirement that it be self-funded. We have been developing education content for quite some time now. I think we have found ways to do it in a cost-effective manner. That doesn't discount the fact that it is expensive to do. And recognizing there may be individuals who are willing to participate, there's going to be costs in one way, shape, or form. That could be if we offer a live class versus an e-learning class, those types of things, different options to consider. But I don't want to necessarily suggest the fact that if the state bar were to offer it, it would be free, certainly, and that it would be, significantly cheaper. I just want to put that into there because I think it's relevant to this conversation. Thank you.
Thank you. All right, Ron Kelly.
Thank you. First, I want to definitely underscore and support Ms. Cruz's point about diversity and accessibility and inclusion here, and just mention that when Ms. Robinson interviewed Senator Umberg, whose bill this was, he said that if there were barriers to entry for less advantaged, less resourced people, that would be a reason for the legislature to step in again with further legislation to guarantee that there were not barriers to entry through this whole program. I'll toss that in. Secondly, although I have the highest respect for Mr. Polewski and all of his work in the field, speaking as an arbitrator who is not a lawyer and who has taught quite a number of people the finer points of summary judgment and who are proper parties and other points of arbitration, I think it is possible for people who do not have a bar card to be fairly decent and to be selected over and over again by large commercial entities to render those kinds of decisions. Thank you.
Thank you. Daniel Yamshan.
Thank you. With all due respect, I would like to point out that there wasn't a consensus that non-lawyers should be excluded. The statute doesn't exclude them. And I agree that with proper training, that they should be qualified to arbitrate cases, particularly since they're going to be handling cases within a very narrow subject matter, most likely. So in terms of providing training, I realize that, yes, it costs money to develop a training and to present it, and it does need to be self-sustaining. But you've had several people, at least on the arbitration side, already volunteered to participate in developing and presenting such a training. So I don't think that's an insurmountable barrier for the state bar to overcome, because the labor costs would be taken care of other than staff time, and the material printing and so on and so forth, if you do use hard copies, could be included in the fee structure. Thank you.
Thank you, Daniel. And maybe I said something imprecisely or misspoke. I believe that Cliff was saying that that was his personal opinion, and to the extent that we have consensus, I think that our consensus is that there should be a pathway for non-lawyers, and I think that Cliff was expressing his personal opinion. So I apologize if I did anything to muddy the waters there and imply that there was a consensus in the subgroup that non-lawyers should be excluded. All right, Dr. Getz.
Thank you so much, Judge Lucky. And I also want to echo, I have tremendous respect for Mr. Polewski, but I did want to follow up on the comments by Ms. Cruz, as well as Mr. Kelly, in talking about this. I would ask all of us to take a step back for a second and think about the implications of what we might be communicating. My specific proposal to the subgroup is that we eliminate the separate track for the ones not admitted to practice law. It's a distinction that is not recognized currently in the field, generally, although I will say that in some panels you cannot become a chair unless you are legally trained. But the step back, I would say, is, look, we're a working group for the state bar. Think about it for a second. The field does not have this distinction that we're now trying to create in training. They don't have that distinction. So our first opportunity to regulate in this field, and certification is a form of regulation, as we learned from Dr. Kleiner, is to draw a distinction between arguably attorneys and those other professionals. And I think that's just a bad communication from us. And I would think about the larger implications, and I want to go into those. I understand people's reluctance but the field has been working well with the variety of professionals we have in there. And there's really no provable difference that we can cite. There's no report, there's no statistics, it's just our feelings. Well, let's talk about that. First, it's going to have a large effect on who wants, and I'm following up on Ms. Cruz's comments that she made largely in the mediation area. But it's going to have a large effect on how many firms want to join us in this certification effort, or even practitioners. A lot of industry-specific panels, real estate, securities profession, which I work on, would be reluctant to sign up for a program to certify their arbitrators, which draws a distinction between their various arbitrators. And you might say, well, we shouldn't care about that. But I would say we should. And the reason is we want to make this certification program broad-based, diverse, inclusive, and the more people we keep out, the more the ones who want in are going to have to pay. This is a self-supporting program. And it's just from a business standpoint, if you think about it, it's going to be difficult to sustain it if we draw distinctions the field doesn't already draw. I think the training component is critical. On here, you have the 8 hours versus the 30 hours. And Judge Lucky, you're very careful to say 1 semester. But the reality of it is, there's 2 things. I've looked through the programs that are in the report. And these programs are not 1 semester. You can't sign up for any of those programs, supposedly for this top track, without spending $4,000, which it would be roughly 4 times what the other tracks would have to spend on training. That in itself should send us a message that maybe we're not ready to make this distinction. We shouldn't create this barrier. I realize it's a voluntary certification program, but I think we have the duty to get as diverse a group in here as possible. I would also say that anything you were concerned about could be taught in an 8-hour basic arbitration training for the most part. And I just, so I don't really understand the distinction, what the other 22 hours are going to do. In looking at, and thinking about Mr. Polewski's comments, and looking at the programs that are suggested that could cure those, the ones that are $4,000 or more, I looked at the content of it from an educational standpoint. I don't think they actually address anything that Mr. Polewski was concerned about. Well, I'm sure more education is always good. Educators always say more education is good. Knowledge is good. I think I saw that in a movie once. But I really don't see the need for a separate track. I think it sends the wrong message to our community. And I also don't think the cure that we so far have uncovered is actually a cure for whatever we think might be wrong. So again, all I'm suggesting is that we eliminate the separate track for not admitted to practice law. I'm not, the other tracks can all remain. But of course, the heading might not be admitted to practice law. It might be, whatever new heading would encompass the entire field. Thank you for not throwing tomatoes at me. I appreciate everything. And thank you for letting me speak.
No, thank you for the comments. Appreciate you. All right, Mr. Eric Tuckman.
Thank you. A couple thoughts. One is I want to reiterate or maybe make sure, Judge Lucky, that I heard you right. Interim awards, partial final awards, those would count for the purposes of qualifying arbitrations. Did I hear you right on that?
At least that's the consensus as of right now. Again, we haven't finalized where we want to be on this, but the general consensus was we were looking for, were the arbitrators making a reasoned decision on the merits of contested evidence?
Yeah, and I agree with that. I think that makes a lot of sense. As you've said, in many instances, those partial final awards are really complete awards. They're just, maybe an attorney's fee issue that's outstanding or something else. Sometimes arbitrability issues are put into a partial final award format for various reasons, but sometimes again they can be quite substantial or dispositive motions as well. Anyway, so thank you for that clarification. I did also in the definition of qualifying arbitrations question there. It reads that they must extend from appointment through award and must be at least 2 hours in length. And does that assume that there will be oral, that there's going to be in-person hearings, and that they must be 2 hours in length? There are a lot of documents only cases actually, and some of them are quite substantial. It's not always the case that they're expedited. Usually that's what we're talking about with documents only cases, but they can expand to larger, more complex cases. So I'm not sure about the 2 hour requirement. But again, the first question, am I right that assumes there's an in-person hearing? But maybe it's virtual, but there's some convening of parties, right?
Yes, and so that's a great point, and it's something that I noticed as I was reading it. You always notice the ambiguity right before you're going to present, and I saw the ambiguity that you're bringing up. So I think that a lot of this stems from one of the things that Cliff Plesky brought up, which is there are a large number of consumer and employment related cases that, depending on your perspective, some claimants feel that, well, this was not really an arm's length type of transaction that brings me out of court and into arbitration. And I think that for people in Mr. Pilevsky's position, I don't want to speak for him. He's going to speak for himself in just a little bit. But some of our conversation was, is this somebody who is used to hearing evidence, has heard contested evidence, and has had to make credibility calls? And isn't that what we want for certification? And so that was kind of the idea. And so and we talked about, well, what about things like motions for summary judgment? And I think that the component that we felt was missing there, even though what you're doing as an arbitrator is still rendering a decision on the merits when you do one that's just on the papers, is that it didn't have that component of gauging credibility. And because we saw this as a consumer-facing certification, right, as opposed to, say, some of the other certifications that the state bar gives that are require testing, to be, say, a certified specialist. We were looking for how does a person who is in more of a consumer role, how is that person able to understand what certification means? I don't know if that helps clarify. And again, we're not final on this, but that's a long way of saying, yes, it is 2 hours of some type of hearing as opposed to just on the papers, either by Zoom or in person.
Okay. That's okay. I think maybe just clarifying that point might take care of that. And that was it. Those were my thoughts.
Thank you so much. All right, Cliff
Oh,
Pilevsky.
I'm sorry.
Oh.
Just one additional question. In your consideration of peer review, did you come across any programs currently in the arbitration context that provide that? I do know about mediation. There is some of that I've seen, but I have not seen it in the arbitration context.
And the short answer is the closest thing that I came up with is I know that we have I'm a member of an ADR group that meets occasionally. It focuses on arbitration. It's usually some type of presentation, but we have had more discussion oriented, or at least a discussion component in some of the meetings. And I would say that that's about the closest that I have. One of the things that I would say, and this is something that as judicial officers, one of the exceptions to ex parte communications under the judicial canons is the ability to consult with research attorneys and other judicial officers on particular problems. And I think that lawyers have that type of facility. They have to maintain confidentiality. We haven't reached consensus on this, so I want to be very clear that this is just my musings on the topic. So I think that there are parallels in other decision-making processes, whether you're talking about Article 3 judges who have a legal staff, whether you're talking about state judges who may or may not, appellate justices who talk to each other. I think that there are some models out there, but I'm unaware of any specifically in the arbitration context.
Okay, thank you.
All right, Ms. Pileski.
Yeah, and I don't mean to beat a dead horse, and I really do appreciate people's kind words, and I also respect people like Ron and others who are able to successfully conduct arbitrations without a legal background. My approach to this is I recognize that we want to expand the field and encourage diversity, completely support all of that. I was approaching it exclusively from protecting the public, which isn't necessarily the same as expanding the field and the rights of people who have been doing arbitrations. I wonder whether part of that additional 30 hours can and should relate to legal training. I don't know how many people on the JAMS or AAA commercial panel, for instance, or employment panel are non-lawyers. I know that there's some in the labor field who are just doing traditional labor work and medical. But there are certain areas where it's just hard for me to understand how you could do the job correctly, like summary judgment motions or demurrers. There was a comment made that the system's been working well, and there are places where it works well. But for instance, FINRA. For years, FINRA did not require a legal degree, and it was a disaster. Arbitrating or even making objections or presenting legal claims to 3 non-lawyers was such a bad idea and such a disaster that they now require. They changed their rules to require a lawyer on those panels. And I realize that I'm not representing the majority here, and this is not a hill I want to die on. But boy, oh boy, you need to know how. Right now, even the courts, even trial judges, are getting reversed once a week or twice a week on decisions on conscionability or arbitrability. And it's just hard for me to imagine how someone who can't do research, who can't put civil procedure and evidence and complicated issues of employment law or commercial law, can't do that kind of research, can do this job in a way that we can represent to the public. So maybe the solution is to create a requirement of certain legal training to at least get you over the hump for certain kinds of arbitrations. And I don't mean to say people can't do the construction or the medical or any specific kind of arbitration, but I am real nervous about certifying people on behalf of the state bar who wouldn't know how to read a case. I'm done.
Thank you, Mr. Pileski. I see Alan Wiener's got his hand up. So, Mr. Wiener.
Sure, thank you, Judge. I just want to address a couple of things about the availability of training. I did the research with some help from artificial intelligence in that document that is attached as I think it's Exhibit 4 to the memo on this item. It wasn't an exhaustive research by any means. It probably spent a couple of hours trying to identify programs and then to look at them to see whether they were really programs that were potentially relevant, particularly in the, if you will, the category of arbitrators who are not admitted to practice. A couple of the state colleges do offer programs, and there are links to them up there, as I believe it was both Ms. Cruz and Dr. Getz mentioned. Cost for those programs, they're entirely online, and it's $39.99 or something like that. So it is $4,000, and that is, it's not pocket change. But on the other hand, for somebody who doesn't have a legal background and wants to have the credibility of state bar certification, presumably they're anticipating making a lot more than that. It strikes me as a relatively small investment. One doesn't need to travel to Pepperdine and do a complete Masters of Dispute Resolution program. And it does appear to cover a lot of the general legal topics, legal procedures, and such. So it perhaps doesn't cover, and I haven't attended the course, so I haven't seen a full syllabus, but they do list kind of general topics that would be covered. So to me, that doesn't seem like an unreasonable barrier or cost for someone who's not a lawyer to become certified in the field. I looked at it particularly if you look at the investment that somebody who is a lawyer has made. I went to law school a long time ago, and it was a lot cheaper than it is now. But somebody who wants to go to law school and become a lawyer and go into the field of dispute resolution and become certified, I suspect is spending upwards of $100,000 to get that certification. And maybe they only want to practice ADR. Maybe they never want to go into the actual practice of law in the more traditional sense. So, I'm concerned about people from lower income backgrounds for whom that may be problematic. And I think that's something that can and should be thought about. But I'm also concerned about the public perception if somebody goes to an arbitration with the state bar certified arbitrator, and they present evidence and they feel like the award just doesn't look at the evidence at all, or makes what would be considered egregious errors of law, and concerned about how that might reflect on the state bar program, and how that might come back to haunt the state bar, and how Senator Umberg would think about that if it hit the press. So I do have those concerns. I also want to mention that in some of the post-meeting communications by the very diligent arbitrator subgroup, there were discussions about whether even arbitrators who are admitted to the bar ought to have a practice requirement of something like 5 years, which is the requirement for being in the state bar fee arbitration program. And that raised the question of whether what the parallel would be, if you will, between arbitrators who are admitted to practice and arbitrators who are not admitted to practice. And I think there seemed to be a sense that it wouldn't be appropriate to say that arbitrators admitted to practice need to have a 5-year requirement, but arbitrators not admitted to practice would not need to have any kind of sort of parallel experience. And in sort of brief discussions, email exchanges, it seemed like that was a little bit of a stumper, if you will, for the arbitrator subgroup. So, if you're talking about a contractor who is an arbitrator, perhaps 5 years of professional experience in arbitration, but there's so many fields that an arbitrator may have professional experience in. It just seemed like it would be a struggle to come up with one rule that would provide a parallel in all of those circumstances. So just with those comments, I would also want to thank the Judge Lucky and the members of the arbitrator subgroup for all the work they've done, all the thinking they've done, all of the problem solving that they've tried to do around this. And I think the assumption is that they're going to go back and do some more of that and hopefully come back to the working group with some more ideas about that, hopefully at the August meeting. But I wonder if it might be appropriate, as was done with the mediator subgroup, to hear from other members whether there are specific things. We've heard some concerns, but whether there are specific things that members of the working group might want the subgroup to look into that haven't already been addressed. And the last thing I'll note is that the meeting's gone on for 2 hours and more than halfway through, and wondering whether it might be appropriate to give folks a break before engaging in that discussion, or at least soon after.
I'll make a note that I see Paul DuBois' hand up, but I think I saw a thumbs up for a break. So let's I'll write down that Mr. DuBois has his hand up, and then I saw just before we break, I want to make sure that my notes are correct. I saw Ms. Cruz's hand go up and down, and I saw Dr. Getz's hand go up and down. So I wanted to find out whether that was purposeful that you took your hand down, or whether that was inadvertent and you still had something to say, and then we'll take those up after the break as well. So why don't we start with Diana Cruz?
No comment in this time. Thank you, Judge Lucky.
Thank you. And Dr. Getz?
No additional comments.
Okay, great. So Mr. DuBois, is it okay if we take our break, and then I promise you'll be first up in the batting order?
Okay.
All right, Chair, I'll turn it back to you.
Thank you. All right, how about 4:15? We'll be back at 4:15. So if you'll just mute yourself, and if you'd like, turn off your video, but please don't go away. We'll be back at 4:15. In session, we're back in session, and we're back on recording. So Judge Lucky, I'll turn it back over to you.
Thank you so much, Chair. And I promised Mr. DuBois that he would have the first word, so go ahead, sir.
Thank you, Jack, and appreciate that. I just want to comment on Alan's position about his concern about the state bar training, and if some arbitrator messes up and he was trained by the state bar, that would reflect on the state bar program and cause the legislator to react. That's going to happen if it was a JAMS arbitrator, or it was one of the $4,000 programs. It'll reflect on those maybe, and it might even cause a legislature to do something. Who knows? I don't think that's a concern. And I understand where Cliff Pilevsky is coming from. There are certain areas where it's better to have a lawyer, like in the employment areas that both of us do. I also do a lot of withdrawal liability cases. I think you need a lot, ERISA, that's ERISA withdrawal liability. You need an attorney for that. But there are so many areas where it's better where you have non-lawyers. And I don't know how we can differentiate, for example, in medical malpractice, a lot of doctors get on there. Construction's a good example. It's often a labor of love by people in the construction business to take part. Even in the securities area, which I did when I first started arbitrating, where they have people on the panel who are former securities practitioners. And they're there because of their knowledge of the securities business, or purported knowledge of the securities business. And so I think it's just difficult to bar non-attorneys, and I therefore support the arguments that we have no separate track for non-attorneys, even though there is some, it's not an implausible argument to have this separate track. But I think on balance, there's no way we can do it. Thank you.
Thank you. And then Cliff Pilevsky, I see your hands up.
I promise this will be the last one. During the break, I checked. Judge Lucky, I'll defer to you, but it looks as though in order to be a Superior Court judge in California, you need to be a lawyer member of the bar for 10 years.
Correct.
And Paul, thank you, but we're not trying to bar anyone from doing anything. This is simply a matter of certification. And one of the distinctions is there are areas where you may want to use someone who's not a lawyer. But in the world in which I normally exist, and most consumers exist, we don't get to choose who the judge is, who the arbitrator is. And so even though there may be cases where it's better to have a lawyer, we don't get a say in that because the person writing the former agreement is choosing whether it be JAMS or AAA or the National Arbitration Forum or some agency they made up of their friends. So without the vetting of the judiciary, without, no, we're not trying to bar anyone from anything except to protect people who don't have a say. And one thing that's clear to me is arbitrators have more power than judges, because when we talk about legal errors, theirs are unreviewable. And I'm done. But if judges need to be lawyers for 10 years, I don't think it's people are going to be screaming about how we're banning non-lawyers from becoming, Superior Court judges. That's not really the concern.
Thank you so much. And I think, in listening to this is just, again, kind of my rumination, but I wonder if there's another component to things like consumer and employment arbitrations where maybe there's a legislative fix that needs to take place for that kind of protection that might be outside the scope of what we're doing as far as certifying within the parameters that we currently have, as Dr. Katz and Ron Kelly have pointed out. I think this is great food for thought for the next time that we meet on our subgroup to figure out what is our charge and how far and deep do we go in terms of creating other conditions. And I see, is that Daniel Yamshawn? It just says Daniel now, but I'm thinking that's Daniel Yamshawn.
Yes. We've now heard today two aspects where the legislature might have to step in. The first, as I recall, had to do with this program not interfering with inclusion and so forth. Relying on the legislature, I'm reminded of what Bismarck said, which is anyone who loves law or sausages should watch neither being made. And it was the sausage making that got us here in the first place. So I think that we should be wary of trying to rely on the legislature too much.
Thank you so much. Okay, I don't see any other hands. So, Chair, if there is nothing else that you need from me, I know we have other agenda items, and I don't want to take up too much extra time. So, if there are any questions that you have for me, Chair, I'm happy to answer them. And then if not, we'll move on.
All right. Thank you, Judge Lucky, for your very thorough presentation. So Judge Lucky, I'm looking to you now. It looks like your subgroup is working very closely with staff because the staff recommendation is up. And I'm sure that with the comments that we received today, staff would like to consider them. What would you like to do as far as your subgroup is concerned? Do you think that with the comments made today and the staff recommendation that your group might want to meet again, as you said, and perhaps have a recommendation for us?
I don't think I'm speaking out of turn if I say yes, we do. And if I see any hands go up from my subgroup showing a disagreement, then I'll withdraw that. But I know that we're having pretty vigorous conversations by email up until just a couple days ago.
All right.
Thank you, Chair.
Thank you very much. And that's really good to hear. Thank you. And Mr. Weiner.
Yes, thank you, Judge Bashan. So I note that both of the subgroups are going to be giving further consideration to their recommendations. We have just about 4 weeks before the next working group meeting, which is in August 20th, I believe. And I'm reluctant to say this, with all of the hard work that everybody is already putting in. But anything that members can do to, we'll be sending out new polls, probably not for meetings next week, but probably for meetings beginning the week after next. And anything that you can all do to respond to the polls quickly and maximize your availability. I know it's hard. You have full calendars and sometimes things fall off and sometimes they don't, but just please work with us in trying to get these meetings scheduled. And I guess staff had hoped that there might have been some decisions by the working group today. There was excellent discussion instead, but we're looking forward to the decisions by the working group so that we can form the new working groups and move forward to the greater public comment that everyone's expressed interest in. So excuse me for asking you to work even harder and be even more available. Thank you.
Thank you. Yes, and that's true. All right, we'll move on to the next item, which is the discussion regarding certification tiers for mediators and arbitrators, and that is being presented by Mr. Weiner.
Thanks, Judge Pashan. So hopefully you are seeing a screen share of something that looks familiar from our very early meetings that we call the topics list. And the idea in this topics list remains the same as it was initially, and that is not to really discuss on the merits these topics, but we want to build out the bullets under the topics of subjects that the working groups are the subgroups that are ultimately appointed to look into these should be thinking about. So I think the plan is to do the same as we did, I think, the first or second meeting, kind of scrolling through these and seeing what might be fleshed out for these subgroups when they're ultimately formed. And so the first one was tiers or levels of certification, something that's come up many times in discussions in both the working group and the subgroups. And this is the statutory provisions, different levels or tiers that meet the specified requirements, accountability and consumer protection, not reflecting an assessment of quality, and only referencing specified standards of conduct. So the task here, if you will, is to look at these topics. I don't know if my screen is large enough so that folks can read them, or if you have them available on your screen, but the question, I'll sort of kind of fly through them. What is a higher level of commitment to accountability and consumer protection that doesn't reflect an assessment of quality? What are some other models for tiers that the working group might look at? And I think this number 3 is something that's been on folks' minds throughout, is can the tiers serve as a way of achieving a lower barrier to entry and still allowing development or incentivizing development of skills? Questions about questions of statutory interpretation, some of which have already been discussed and will be delved into further, I think, by the subgroup. But if you had a subgroup that was starting to meet tomorrow to talk about tiers, what else might you want them to have kind of on their agenda to think about, if anything? And I see Ms. Cruz.
Yeah, a few suggestions, but I'll just do 2. One is more training on consumer protection and accountability. So higher levels of training on specified sort of ethics, consumer protection, disclosures, complaint procedures. And then second, that we've been talking about a lot in our subgroup, Alan, apropos of your concern of like, what if this guy's certified and he's never done an arbitration before? More disclosures on specified topics. Like when you raise that hypothetical we discussed about, well, what if people put on their websites, more specific information, right? Like, and to Cliff's point, right? Like that I'm not a lawyer, or that I specialize in only these three things, or that I've only had, 4 arbitrations through final awards, things like that.
Great, thank you. And I'm just going to note, I think it was in the arbitrator subgroup that this topic came up a couple of times, and I think sort of under the title of transparency. And so hopefully that will resonate with the subgroup who looks at it. Mr. Kelly?
This is a topic on which I would really like Cliff Pilevsky to weigh in with specifics of what problems he has seen of neutrals violating what he would consider appropriate consumer protection, because I know he's been a strong advocate for decades for stronger consumer protection. So I'd love to hear what Mr. Pilevsky has to say on what's missing.
Mr. Pilevsky, do you want to weigh in on that now, or you want to think about it?
You have a hard time shutting me up. We probably don't have enough time. But going back to transparency, transparency is great. Just the same way knowing agreement is great, as long as you have voluntariness. If we don't have the ability to make a choice, you can disclose all you want. If we don't have the ability to say no, or to choose or participate in the actual selection of the panel. I think the biggest problem, and it's not one we can fix, and it is, in my mind, the cure to everything that's wrong, or anything that's wrong with ADR, is the lack of consent in mandatory arbitration. The difference between what you folks are doing in mediation and what I'm arguing about is mediation is a voluntary process. And both sides are actually involved in choosing the mediator and can make whatever choice and informed choice they want. I'm a big fan of arbitration and in party autonomy to design a system that works for them. But that's not the world that we're living in. I think the biggest issues in my world are inadequate ethics standards. I don't think the providers have ethical rules, standards. I think that there are some that try to do it well, and it has become a tremendous business opportunity for others who don't fly by the same rules or believe in the same rules. I mean, the marketing that's going on out there is unbelievable, and how biased it is in the development of rules. And I just think that we need to ensure confidence in the system. And when the courts have ripped away the requirement of consent, they've really made it hard. I think that, it is actually the courts that are undermining the value and integrity of ADR, and that many of the abuses that occur in the mandatory settings are spilling over and undermining the usefulness and the popularity of other forms of ADR. So I think the ethics rules, and again, something I said earlier on is that I got so many dear friends who are great mediators and arbitrators, and I know that most people think they can be fair. And whether you think you can be fair or will be fair is not the test. And I just do not believe that the providers believe they have an obligation to be neutral in marketing and in administration necessarily, in rules drafting. And I don't think the appearance, I think everyone needs to adhere to avoiding the appearance. How does it feel to the person who shows up in your courtroom, conference room, non-consensually? And I don't think we're spending, I don't mean this committee, but I don't think the industry is spending enough time concerned about it, because from a marketing, revenue generating standpoint, they don't need to. And I really think that we're not doing enough to address that. I can be more specific, as to the best example, which I'm going to be talking about in future meetings, is the notion that arbitrators can take unlimited cases for hundreds of thousands of dollars from one party to a dispute during the pendency of the arbitration. It's an outrageous concept that if I'm in the middle of an arbitration and I go to a professional event and I see my arbitrator, who I may have known for 10 years, I will avoid that person because I think it's the right thing to do. It's inconceivable to me that that arbitrator could think it's okay to do mediations, all-day mediations, and 7 other arbitrations, despite the obligation to avoid ex parte communications, despite the obligation to avoid the appearance of a conflict. And it really concerns me that if you're going to assume the awesome responsibility of being a neutral with binding authority, you got to put aside your own financial interests and your own belief that I'm neutral, because I don't think that's happening in the outside world sufficiently.
Thank you. Judge Lucky, I see your hand.
Thank you. And I'm going to push back some on what Cliff is saying, and I really enjoy being on the subgroup with him. But the thing that I'll point out is I think that some of the complaints that Mr. Pileski has are complaints with published decisions by the courts, the standards of judicial administration, or the rules of court. They may not be within the scope of what we're doing for certification. And I wholeheartedly think that we should look at these issues. And I'm not saying that his issues are invalid, but I understand from his perspective and maybe from his client's perspective that he's saying this is involuntary. The courts have decided otherwise, right? The state of the case law is that people enter into arbitration contracts in a number of different contexts. I understand that people can have principled disagreements with how the California Supreme Court has come down on the issue, but they've spoken on that issue. And so I think that the goal of changing what the Supreme Court has done through, or our appellate courts have done, or what the standards of judicial administration or rules of court say, and where Mr. Pileski thinks that those are falling short of what they should be, I understand his thinking. I don't know that that's what we're doing here. And so I'll leave it at that.
We can do ethics rules. We can't say you can't arbitrate, but we can certainly enhance ethics rules. That's all that's left. I understand and I agree. Believe me, I've got the scars to show what the Supreme Courts have done. But we can do ethics rules, and I think that's what the legislature wanted us to do.
Thank you, Judge Lucky and Mr. Pileski. I just want to reiterate here that the task is sort of to build an agenda and not so much to resolve the items in the agenda. That will happen more in the subgroup discussions, and then they'll come back to the working group as we've been doing. So, Ms. Cruz.
Maybe just trying to harmonize those 2 points of view, training on things like arbitrability, jurisdiction, and unconscionability specifically. We can't change the law. I agree with Judge Lucky, and the courts have spoken, but maybe we can give arbitrators more training on that, Cliff, to help avoid the issue of true lack of consent. And then in terms of maybe under how to ensure confidence in the arbitration system, perhaps actually here, sort of thinking about what Daniel was saying, maybe if you're a trainer and train on arbitration ethics, that helps you with this tier in terms of accountability.
Did I capture that about right? So higher tier, you're suggesting, okay. And you had mentioned 3 things: arbitrability, unconscionability, and you had a triad there.
Oh, jurisdiction, although that one is kind of one thing that I've seen, though, that some arbitrators don't know is whether an arbitrator or a court has the power to decide their jurisdiction. And so maybe that's the distinction I'm making, Alan, like that first step in the analysis that I've seen some arbitrators miss.
Thank you. Anyone else want to give assignments to the subgroup that's going to talk about tiers? Hearing none. I'm going to, oh, there were, I think I went through these before. Oh, Mr. Kelly, I see your hand now.
Maybe it's obvious or just seems obvious to me, but the more you do something, the more you get the hang of it. And if we're trying to find something for tiers, experience seems like something that I'd like the subgroup to look at.
Thank you. Ms. Cruz again.
One thing that perhaps pervades this whole issue, but that one subgroup or all the subgroups should talk about is just the importance of like disclaimer language in terms of the higher levels of tiers and the statutory language. If you just run back up that this is not an assessment of the quality. And because I think to Cliff's point on consumer protection, one thing that was really concerning to a lot of the boards that I'm a part of is you're going to put this stamp on somebody of like level 1, level 2, level 3, and people are going to think that the highest tier is the best, neutral in the world. And so we've got to really guard against misperceptions and protect both the state bar and the public in that way. I don't know if that's this group or all the groups or a special group, but something to really make it very clear what we're doing and what we're requiring and what that means when you see like the little sticker on Ron's, website.
Thank you. Anything else on tiers for right now? Okay, I'm going to move on to another topic that's come up pretty frequently, including today, is certification of firms or provider organizations. So we have, one question is there a difference? The statute refers to both firms and providers and practitioner, or all three. Is there a difference there? So sort of a definitional question. Is other language for firms, if you will, referring to them as provider organizations, as has been done in other sets of standards? What constitutes a firm? What's the difference between a firm and an individual practitioner? Do two people make a firm? Is a practitioner who has an LLC or a corporation a firm? Is a court? And some of these, I think the ones in green have come up in earlier discussions when we were discussing other topics, and they were sort of moved down here. So is a court program a provider? And a note that the Judicial Council has definitions, and that I think refers to the Judicial Council ethics standards. So what's the difference or distinction between certification of organizations and practitioners? So we've all been working very hard to determine what should be required for a practitioner to become certified. Which of those are transferable and aren't transferable to provider organizations, and what needs to be added for provider organizations that doesn't apply to individual practitioners. Statutory requirements, or the statute speaks of firms needing to have ensure that their practitioners or require that their practitioners adhere to the specified standards of conduct and have complaint procedures and remedy procedures. So should there be, though, I mean, that's kind of built into the statute now, should there be other requirements for firms or provider organizations? And should organizations be certified overall or for specific processes? So if you have an organization that has neutrals who provide a variety of different types of ADR services, how does that get reflected in the certification of the firm or organization? So what's missing? Mr. Kelly.
For quite a while, a ways back, two large ADR provider firms were trying to get the California Association of Realtors to name them specifically as their provider organization. And at one point it was one of them, and at another point it was another one of them, and then they moved to generic qualifications. What I was trying to push at least one of them to do was to have their model language say, okay, we're the provider organization, or the parties can choose whoever else they can agree on as part of contract language. What I'm trying to get at as a topic here is firms that look to be the exclusive provider for all of the California Association of Realtors or Bank of America or other firms, which then cuts out people knowing they have a choice of somebody else they can agree on, getting to Mr. Polewski's point about being trapped into a particular provider. I'd love to see firms somehow required to put in language if they succeed in getting to be the only provider for large organizations, to put in something simple like, or anyone else the parties can agree on. That's the point I'm trying to get at.
Thank you. I think I got it. Mr. Polewski.
And just as you're thinking this through, the providers create the rules, which can be outcome determinative. They appoint the panels. Sometimes they create the panels, even if it's a selection of 7 people, who's going to be on that rank and strike list. They rule on challenges for cause. They conduct the trainings. And you should see some of the trainings that FINRA used to do. They used to literally tell people you're not bound to follow the law, and punitive damages should be reserved for egregious cases. Not garden variety fraud is how they defined it in writing. They have other flows of income aside from case administration. Let us design your programs for you, pay us for access to our computer systems, and they view many companies as clients. They actually use the word clients to define people. So there's a whole bunch of things that are outcome determinative that impact the system that we're going to need to deal with when we talk about providers.
Thank you. Anyone else to enhance this list at this point? And again, as the process has worked in the past, as the groups report, the working group will have input and make suggestions that will go back to the new subgroups to look at. Judge Bashan, if it's with your permission, I'd like to continue through this topics list. We really only have one more right now, and I feel like we've touched on the next agenda item, which is formation of new subgroups a couple of times. So would it be all right if we kind of push through this topics list topic?
Yes, absolutely.
Thank you. So the next,
Alan, I see
I'm sorry.
Mr. Tuckman has his
Oh,
hand raised.
yes, Mr. Tuckman.
I understand the list. I just have a question as they're being evaluated. A lot of these, it's a question of scope, I think, again. So we might draft the rules. I think a lot of the concerns that Cliff and others have raised, there's specifics to things like employment and consumer, and of course, there's a valid debate about employment and consumer arbitration, but it does have to fit within the legal context we've got that we're all working within. We're designing a certification program, so we're not drafting legislation. I suppose you could draft ethical rules that a provider or individuals have to agree to become certified. Maybe that's what we're getting at, but I'm a little concerned about scope as well. Again, not necessarily raising an issue about whether these are valid questions or not, although I do have questions about some of them. But I think we're bumping up a little bit of a scope problem, at least as I understand it, about what this group is supposed to be doing.
Thank you. Anyone else before we move on to the topic of administration, which again we've touched on quite a few times. So the idea of administration is, I hate to say more mundane aspects of it, but the working group and subgroups have been looking at significant questions of ethics, and I'm going to say maybe more substantive types of questions. But at the end of the day, it's going to fall on the state bar to implement this and make it work, have application forms, decide on applications, et cetera. Working group members have already had comments on some of these topics, if you will. You know, for example, should it be recertification or renewal? How often should that happen? Ultimately, I think some of these are going to fall to the state bar to determine what kind of works within their administrative structure. So that's what the role of the working group versus state bar staff was. Ms. Cruz, if you'll just give me a minute, I'll try and go through these really quickly and then come back to you for what you want to add. So scope of certification, I think I just heard something about this. You know, this maybe what Mr. Tuckman had just said could fit under this category along with specific processes versus more broadly. Initial application, what information should go onto the applications? How should it be submitted? We're going to mail these through the post office. Renewal or recertification, I just mentioned frequency cycle, you know, what needs to be included. Is there a difference for practitioners and organizations? Review of the applications, special issues for certification of attorneys. Do attorneys, well, under the state bar rule, currently attorneys who are practicing ADR need to be active members of the state bar. So what is the, you know, how does that fit in with the certification program? Revocation process, grounds and processes, designation of other organizations to address complaints. So the complaint subgroup said that the state bar should be able to designate other organizations to handle complaints. And so how is that going to work out? And then certification and renewal fees, which are sort of a separate topic, but also kind of administrative. So Ms. Cruz, if I may come back to you.
Yep, I would just add two things there. One is on the revocation grounds and process. Most of these things, I think the state bar staff is probably the best, you know, expert to deal with. But on revocation, I think that perhaps you all should consider having a subgroup on that because of the severity of the situation that you're in. And, you know, can you get recertified after you've been revoked, depending on the issue, et cetera. And then I would add to just my point on, is the state bar going to offer the arbitrator training that may come out of the trustees and the working group? And, you know, how much would it cost? In terms, I see the next thing is the certification fees. So getting a good sense of how much that would cost and how much that would impact the overall fees that would be charged to each person or provider, I think is a good thing for the arbitrator group to know in terms of making its recommendations, because maybe we need to go way lower if it's going to cost X amount of money, or maybe we need to think about, well, if we had 30 volunteers, then you could do it basically for almost nothing.
Great, thank you. Are there topics top of mind on administrative considerations? Ms. Curtis, you're on mute.
So we considered this as we looked at the ethics rules, and I think there's something in the standards that says, you know, people need to tell the truth and to the you know, client, future parties, lawyers, and to the state bar on certification. But I think it would not hurt to have something here about attestation requirements. If we're looking at really having a streamlined application process where people don't submit their MCLE certificates and so forth, and they're just merely saying, I've had this many hours of training, then it needs to be really clear. And along the same lines, also, that they will, whatever the language about adhering to the standards of conduct should be very clear and emphatic. And finally, a different topic is, what about the website? What's it going to say? And what information goes up about people who are certified? And is there any information that will go up if someone loses their certification or if it's revoked? And if so, what?
Thank you.
Oh, I have
Yes.
one more. The other is, is there any kind of review process or random check, such as happens with the MCLE program, so that it's just, there are some, even if it's a couple cases a year, that they follow up and ask for proof and so forth?
Thank you. Mr. Yamshan. Mr. Yamshan, if you're speaking on mute.
Thank you.
Thank you.
I'm a little concerned about what proof will be required because there will be confidentiality issues.
I'm just going to make it a separate topic. So proof of meeting requirements. Confidentiality. I think we'll know what, I'm not articulating it very well, but thank you.
Close enough. Thank you.
Thank you. What else is top or near top of mind? Well, thank you. I think this is a great start. Judge Pashan, I think we can move on either to the next agenda very briefly or to an adjournment as you prefer.
Well, I do want to respect everybody's time, and I do appreciate everybody's involvement and participation. The discussion has been very thorough and wonderful, and I appreciate that very much. It is 4:56. We said that we would adjourn at 5, so the next agenda item would have been the discussion of new subgroups, which we can certainly do at another time, because two of our subgroups have asked to go back to discuss what we've talked about today. So I think we probably should adjourn for today and thank everybody for your participation, which has been tremendous. So thank you so much. And I look forward to hearing from the subgroups and to having our next meeting. So we are adjourned.
Okay. Thank you.
Thank you, Judge Prashan.
Thank you, Judge Prashan. Thank you, everybody.
Bye, everybody.